Welcome back to OpenLine. We are talking with Tim Takis, elder law attorney. A lot of questions tonight, and I think they're really good, about caring for an elderly parent. What do you do? What are some of the things you should be kind of planning for and doing? And several good calls. Let's just go back to the phones. Let's go to Marilyn. Marilyn, are you there?
Yes, I am.
Go right ahead.
Okay, I have a question. I'm the parent.
Okay.
And if something were to happen to me, I'm in a bad accident, I'll be 65 this coming January. If something bad were to happen to me where I'm kind of incapacitated and my injury or whatever, I'll never really be able to live in my home again. So my children might need to sell my house to help take care of me and my medical bills and everything. How do I go? What kind of things do I put in process to make sure that they will be able to sell my house? Because I do have a small balance on my house at the present time.
Right. All right. So probably the most important thing that Marilyn needs to do there is she needs to really. It sounds like she's healthy.
Yeah.
You know, and that's really just getting her basic estate planning in place. Estate planning, which really is more than, for one, it's more than just getting, you know, who's going to get your stuff, your property when you die. It's certainly making sure, because what she's asking about is, do my children or would they have authority to act for me? You know, and that's by getting a durable power of attorney in place. Now, one of the things that she probably ought to think about is that if she is healthy and she's either retired or near retirement perhaps or whatever is that she might want to consider looking at the long-term care insurance or something like that, because, you know, I often say people who are in their late 50s and mid 60s are kind of like in the sweet spot for long-term care insurance. And so now it may not be appropriate for her because maybe she has too much money, you know, so she can be self-insured. Maybe she doesn't have enough money to pay the premiums and whatnot. But certainly, you know, any well thought out retirement in estate plan, you know, should at least consider that.
So I agree, she sounds healthy. She's concerned she gets in a car accident. Her house, I guess, is her major source of wealth.
Yeah.
How do her kids then access that source of wealth?
Sure, and then of course she's got a power of attorney, and so they are able to, you know, so basically they have all the legal authority that they need in order to sell the house and use the funds for Marilyn's care. And
I bet the kids and she have, or at least she has thought about, I'm just going to put the house in my kid's name, and you again say don't do that.
And that's where maybe, you know, that if she has enough of a concern to call this program,
right?
You know, it might be a good idea for her to have a conversation with her children and say, look, here's some things that, you know, I'm concerned about. I'm not worried about it necessarily, but that's just called being an adult and planning for the future. You know, and hopefully her children will welcome having that conversation, because a lot of parents, it's a very difficult conversation to have. You know, in fact, it's sometimes so difficult they wind up calling it the conversation, you know, which is the parent and child conversation. So, you know, that's a good opening for her, you know, to talk about that with her children.
Marilyn, thank you for the call. Good call. Let's go to Roberta. Hello, Roberta.
Hi, I've got two questions on two different subjects, if you'll allow that.
Yes, absolutely. Go ahead.
First one, I'm not sure if Tim can be too helpful or not, because he can be helpful if this is kind of a generic situation that he's familiar with. But basically, I'm one of the beneficiaries of an agreement that was signed by, my dad, and then it was a family business, and basically when my dad retired, his brother and cousins and whatever, their children were the beneficiaries. So basically I collect a check, and I had no responsibilities other than, you know, paying the taxes on the check. And this partnership agreement is supposed to last 50 years, and my question about it is, what happens at the end of the 50 years? Is it just split between all the parties? Are you familiar with anything like that, just basically?
Yeah, pretty much. In fact, I worked on a partnership, some business stuff, actually this afternoon. So, you know, among basically an older gentleman who's retiring and buying out. You know, he's going to be bought out of, you know, by his children, and so literally what happens after 50 years. You know, part of that you have to look at what the having the agreement in front of me says. Sometimes it depends on what state law it is. So if it's Tennessee, after 50 years, what happens is it sounds like the partnership terminates. And when the partnership terminates, that basically means that the debts of the business are paid. The assets then are surrendered or sold or whatever it is, and then the partnership assets are divided among, the beneficiaries or the current owners.
Right. Now,
presumably, and when I say presumably, I'm walking on, ground that I'm not so sure about is that the question really, the next question would be is there any way to get around that? And the answer might be is that a lot of that may be depending upon, first, what does the agreement say? And second is that could they get together, all of the partners or beneficiaries, and come up with another agreement?
And now
that says something different.
All right, did she have two questions?
She said you had two. Yeah.
Did you have another one? Go right ahead.
The second one has to do with the fact I'm in the middle of my own estate planning right now, and basically I only have one relative. I don't have children, and I don't have a spouse, so I don't have any responsibilities in that regard, and I'm going to leave everything to charity. And my question is, the executor of the estate, we had some difficulties when this person was the executor of another estate, and I saw how that was handled, and I wasn't real thrilled about it, but it was not serious enough to, go to court or even raise any questions short of going to court, other than just to indicate that the deceased wishes were, that's how I kind of looked at it. It was and she had Alzheimer's, and so that's where some of the questions came in about what her intentions were. So different points in time. So my question is, if I decide to leave everything to charity and leave this person in charge, what kind of oversight do they have? Because there's literally doesn't seem to be anybody that's looking at see what they do. I mean, you could say, well, after you're dead, what do you care? Maybe that's what I need to. That's how I need to look at it.
Well, if you want your money to go to charity, you want it to go to charity. Okay,
exactly.
I think that's a great question.
Sure, it is, and one of the things that we know over, and this is something that we're expecting to start seeing more and more. People like my age. My wife and I, we have no children, and although we have, siblings and we have nieces and nephews, you don't necessarily want to burden them, with administering our estate. So now, what she is saying though, is it Marilyn?
It's Roberta.
Roberta. What Roberta says is that, well, how do I make sure that the charity gets what I want them to get?
And this executor does what I want the executor to do.
And then, so my response might be, to start out, would be is, why don't you go talk to the charity? Because if you know what charity you want to leave your assets to, then they will give you some ideas as to how to make sure that they get involved right from the get-go.
And all right,
does that make sense?
That's a fascinating question to me.
Yeah.
All right, so you don't have kids. You want to leave your money to charity. I think that's great.
Yeah.
But you want to rest assured that's what's actually happening.
Right.
So she has some level of discomfort with the person that is going to be the executor. Why use that person? Is it hard to find someone to be an executor?
Sometimes it can be, because you're going, okay, I've got one relative, and maybe that's the person that she's thought, and she sees firsthand how this person is. They're not so good in complying with instructions. Now, if a person comes into our office and they retain us to do a probate of an estate, then our job as representing that person is seeing to it that they comply with what's supposed to happen. In fact, that's, but that's why I get back to, sometimes the most difficult decision that a person has to make is, who's going to be in charge when I'm not able to be in charge? And that is a difficult question to answer.
And her question was, what kind of oversight is there? So let's say she picks the person.
And the oversight might be in the court, but sometimes if the money's already gone or whatever it is, then...
Because an executor or executrix,
they're appointed by the court.
They are allowed to pay themselves some amount of money for their time.
Right. But it has to be court approved.
Okay.
So they can't... Yes, they have a responsibility to oversee and administer the estate in accordance with the law. But that's where you have maybe she says, okay, I want to make sure this person complies. Well, for one reason that you might say is, well, then don't waive a bond, in your estate plan. So the person, when the personal representative is appointed, the executor or executrix, then a bond has to be posted. But of course, that's paid by the estate. Her estate pays the bond, but that's a choice that she could make. But I still get back to, I start thinking more and more about this, is that because she knows that she wants it to go to charity, get the charity involved, and they will give her some, they might have somebody that, they might have somebody that would be a co-executor,
right?
With this other person.
Makes sense.
Sort of, so that person then does oversight.
All right. Thank you, Roberta. Good question.
It is a good
Let's
question.
go to Ken. Hello, Ken.
Yes.
Go right ahead.
Yes, I am a 57-year-old divorced father of a 5-year-old boy. He's my only child. And I want to leave, I have heard the term trust will before, but I basically want to leave, my house. I just paid everything off. I'm out of debt. So I just want to have it set up so that, if anything happens to me, that, it would be liquidated, everything, insurance, 401k, all of that, and put into a trust that would be delegated to him, like when he turns 25, maybe get 10% because, he's going to blow it. Yeah. And then maybe at 35, age 35, get another percent.
Right.
Where do I begin?
So
do I start at the bank and set up a trust fund?
So it sounds like he's thinking, he's a chip off the old block. So
because he might blow it.
He might blow it. Yeah.
You get a windfall at too young of an age, you probably would blow it. And so he wants to responsibly kind of dole it out there.
I often say is that sometimes 5 years when your child is 5 years old, you really don't know for sure what you're going to get. But usually, probably when they're 12 or 15, you probably have more of an idea of what your kid's going to be like. Now, I don't know that he certainly could go to a bank, but the bank's going to tell him go to a lawyer that will do your estate planning, because that's really what he's talking about. Is that he has an estate plan that has, he mentioned a trust will, and all that means is that he's got a will in which he bequeaths his assets to a trustee. And the trustee that he's designated in his will has certain, it's set out in that will certain responsibilities toward his son. Now, one thing that we know is that let's say that Ken dies when his son is 12 years old, and there's a trust that's set up in the will for his son. Well, since he has a duty of support of his son until the son turns age 18, then the trust is going to have to support his son. Now, once his son turns 18 or 19, graduates from high school or whatever, Ken might want to have provisions in his trust that says, well, if my son is going to college, I want the trustee to help him pay for a college education, or if he's not going to college, maybe some other things that he would like to see, for his son, those sorts of things that he could have put into his will. And then it says something like, but when my son turns age 25, I want to give him a certain percentage of the trust estate. The rest remains in trust. Ken's challenge on that, though, is like we were just referring to earlier. Who's going to be the trustee?
Right. And what if you pick the best trustee in the world and then they don't live as long as when the trustee's gone when your child turns 25? Now,
one thing I always say is that a trust will not fail for lack of a trustee. So let's say, because I've had people come into my office and say, well, I'm 55 years old, and the only responsible adult I know is my father, and he's 80. And I might say, well, why don't we just name your father as the trustee, because, what's the worst that can happen? You die early, and then your father says, well, I can't do it, but at least you've tasked him with finding his replacement. So that's always an option. Or if he's dead, then the judge appoints somebody.
When you identify a trustee and that trustee dies, it's that trustee's responsibility or a judge's responsibility?
Ultimately, it's a judge that would appoint a new trustee. Now, in my documents, I will give the trustee the right to appoint his or her successor. under appropriate circumstances, that is, because sometimes the trustee will go, look, I told my best friend I would do this, but he didn't know I was going to be, when he died, that I was going to have cancer and I might not live for another year. So I'll find somebody else. So those are the sorts of things that are okay.
That's a great question.
Yeah.
Ken, thank you for that question. All right, we have to take a break. If you're on the line, hold on. We will get to your call. Carl, Lee, others.
Speed round, right?
Take a break. Be back right after this.